Welcome, everybody, to the Thursday meeting for the Ag and Seasonal Workforce Services Advisory Committee. Um, let's go ahead and go to the next slide. Take a look. And as you know, this meeting is being recorded. Please be advised that your image and voice will be captured and recorded during the video conference. Your participation in this video conference equals consent to be recorded. Let's go to the next slide. Let's take a look at our agenda today. I guess this is our call to order and our welcome. We will put the roll call off for a little bit just to, as well as the meeting minute approval. We'll push those to the end to ensure that we have a quorum. But we are going to get our office update from Bertha, Olivia, and Susanna. We will be skipping the Workforce Services Division update. Alberto apologizes, but he had an emergent issue pop up and is not able to join us this morning. And then we have a couple H2A program updates for you. If we are doing good on time, we will take a break, but I'll be looking to come back at 10:30 for committee discussion and feedback on our potential meeting scheduling for next year and the preview of our work for next year. It is a report year, so we will have tasks to accomplish through the course of the year. And then we'll move into public comment, go to the order, and get ready for our next meeting, which we can talk about when we get to scheduling, but I do recognize that Thursday, January 15th is the first week of session, and we're double checking to make sure that we're not trying to have a meeting at the same time as some major labor committee or state of the state or anything like that. We're taking a look at that and might adjust as needed. All right, so with that, let's go ahead and we're going to jump to the office update. Bertha?
Sorry, did I miss that we're not doing the roll call at this time?
We're putting it off because I'm not 100% sure we're at a quorum. So we'll just put it off to either right before the break or right before the end.
Sounds good. Good morning, everybody. I'm Bertha Clayton. I am Director of the Agricultural Seasonal Workforce Services Office at ESD, and I'm here to provide a office update at our November Advisory Committee meeting. These slides were submitted on Tuesday, and as of Tuesday, we were still in shutdown mode. And this obviously we have a change in circumstances since that time, but just to kind of review where we've been and where we are now, the government shutdown started 9/30/2025, and the flag portal, which is the online portal where ETA 790s are filed, was closed. You couldn't log in, you couldn't file any of those things. So as a result, no applications for H2A, H2B were filed between 10/1/25 and 11/3/2025. So I say 11/3 because we received a communication around that time from OFLC stating that they had resumed partial operations, although partial was not defined. We do know that during that time, the flag portal reopened and we started getting some applications coming in. So unfortunately, there's been no federal communication or guidance about how to mitigate or otherwise navigate the impact of the shutdown for, I think the total was 40 days. And what we expect to happen and what DOL has told us is likely to happen is that we are going to receive applications filed on an emergency basis. An emergency filing is allowed in the CFR, and it is when a employer has a qualified or a justifiable reason for filing the application sooner than the 75 later than the 75 date of need day date of need mark. The function of an emergency filing is that the review bypasses the SWA timeline and it goes directly to USDOL. The SWA still is responsible for doing housing certification, but it puts the application on a much faster track. I'm assuming or presuming that the reason that will be presented by employers who go this route will be the fact that there was a government shutdown and that systems were inoperational for close to 40 days. Our team is mobilized for that. We've been planning on emergency applications. We have sufficient staffing and processes to handle that, so we're not worried. But we just wanted to let everybody know that we could see an uptick of emergency filings. A potential impact of the shutdown is that growers may not be able to obtain their workers at their date of need. And also the other impact that we saw is that employers who had filed an ETA 790 in the system prior to the shutdown and prior to the closure of flag, the employers that wanted to withdraw that application couldn't. And so they were still responsible for conducting domestic recruitment activities and hiring all willing, able, and qualified workers, which really reinforces the fact that that at the time of filing, employers are representing to the government that they need these workers as of this date. And so this was kind of a special case that we had to do some research on it, but domestic recruitment obligations did continue in that case. So partial, like I said, partial operations started again on 11/3. We specifically received a message from OFLC saying, please don't expect any guidance or ask us any questions because we're just running, running operations. So any questions that we have submitted have been unanswered in most part, and we are standing by to hear more from OFLC about the rule. We'll talk about that in a moment. There's been practically no communication. The other thing to highlight is that there was no impact on our FLC grant. That allocation had already been made, and we actually spend those grants a year's 3-year grant. So there was no, I guess, interruption in our operations due to the federal shutdown. Any questions? All right, next slide, please.
Rosalinda asked in the chat if this meeting is being recorded.
This meeting is being recorded. It will be available on our website likely by Monday or Tuesday. Is that right, Vicki? Is that reasonable to expect?
Probably Tuesday.
Okay, perfect. So speaking of impeccable timing, the 2025 AWR rule was published on 10/2/2025, which was during the shutdown. So I think, got the email maybe a day after the shutdown had begun, and as a result, there was no communication line between the SWAs and USDOL regarding how to implement the rule, how to interpret the rule, how to change our processes and evaluating certain language in the job description, etc. Luckily, we have a strong peer group of other SWAs. We meet with them monthly, and so we had that support, but really they weren't in a position that they're in the same position that we were, and really kind of not having any information about implementation of the rule. We've received a lot of inquiries from employers, from associations of, what does this mean? How would you interpret this? And our messaging has been however USDOL tells us to, and USDOL has not told us how to interpret. So the potential benefit of having emergency applications filed after the shutdown is that we'll be able to get a preview of how USDOL is interpreting language specifically about experience requirements of the job, etc. So we are hoping to get a glimpse so that we'll see how they're interpreting but there's been no commitment for guidance from USDOL to this point. Go ahead, Elizabeth.
I'm sorry to be off camera. My Wi-Fi is my Wi-Fi and electricity is an issue. But I'm curious if the ESD and the State Attorney General's office has been in communication around, potentially pushing things down with the housing. We're concerned about, obviously there's going to be some sub-minimum wage conditions created, and has the Attorney General's office been in communication with you about how about how state laws are going to intersect with the wage rates?
I'm coming on camera to answer that one, and we're going to talk about this in a little bit, but yes, we are talking about it. I think little preview of where we're going with this. ESD is partnering with Labor and Industries and our associated attorneys general to review the rule and enter a comment during the comment period. And that is one of the things that we are noting is that we need legal guidance on how to interpret the sub-minimum wages and what the decision will be on that. Can't speak to that directly because that's L&I, and I am not entirely sure of how we manage that in the wage and hour division, but we are working on it. And Caitlin came online to.
Yeah. And I can just add, we did release rates for next year. So the minimum wage in Washington will be 17.13, which, as Joy indicated, and Elizabeth, you also indicated, will lead to potentially the rates that were posted being below the minimum wage. Regardless of Washington, workers are entitled to the minimum wage rate. So that is something where if a worker was receiving kind of the rate established under the new AWR rule, and they were getting less than the minimum wage, that would be something that we would investigate if we received a complaint. So we're looking at it as well, to Joy's point, but just across the board, workers are entitled to the minimum wage in Washington state.
Thanks,
Add to
Caitlin.
that, what this new rule doesn't change is that the state minimum wage is still the floor. So, since I've been director, there hasn't been a situation in Washington where the highest applicable wage has been the state minimum wage. And under this new rule, it's likely that under some circumstances, the state minimum wage will be the highest applicable wage, but it's still the floor, and this rule doesn't change that. Okay, next slide, please. So this was covered in our last meeting, but I just wanted to reemphasize it. We had a pretty, I think, substantial conversation about specific changes to ESD's housing certification process. As you know, in this program, the SWA is really the last say, the final say, and really the only say that matters to USDOL when it comes to certifying H-2A housing as in compliance during the application processing. So just want to reemphasize that ESD will require all H-2A TWH to have a valid DOH temporary worker housing license. This includes units that are 9 and under occupants that were traditionally or historically inspected by L&I. This move or this decision by ESD brings more alignment and more uniformity to the housing certification process for H2A housing only. I recognize that there could be 9 and under temporary worker housing that's not H2A. That's not that would be outside of this analysis. We're speaking about H2A temporary worker housing only. There is an exception, and that exception is mobile range housing. So that starting 2026, mobile range housing will be inspected by our team according to federal mobile range housing standards. So we will be using the federal checklist. The federal checklist still requires state compliance with things like sewer, or not sewer, but excrement, waste, water, but those are on the checklist, but everything else will be according to the federal standards. Our state law currently does not contemplate situations in which RVs or mobile housing would be used as temporary worker housing. It's a gap in our rule. So therefore, that subset of housing would not never qualify basically for a DOH license because of things like ceiling height, minimum square footage, etc. So we will be doing those. We have a SOP that we have developed for our staff, and these are probably, we have like maybe 15 or less of these. It's not a heavy lift, but I think that we'll be able to get to these employers much sooner. The process will be much more clear. There won't be a fee for housing inspection. So there is a carve out for mobile range, and I just wanted to reemphasize that. The other thing I want to emphasize is something that has always been the rule, but I don't think that maybe we've highlighted it as much as we should have been highlighting it, is that the CFR and OFLC expects that H2A temporary worker housing be ready for certification at the filing of the ETA 790. So when you file, you're representing to OFLC, to ESD, that your housing is ready for inspection, or that you already have a license and you're ready to go. This is important because we really want to, avoid situations where, DOH has to come out multiple times, or, and those things cause delays. And if we can't certify your housing, your application can't get certified, and there may be a delay in your workers. So DOH has done a lot of good work this year, making sure that employers, also operators, know what's required and have all the tools to be ready for their inspection or have their license when at the time that they file their ETA 790. Any questions about that? Next slide, please. In my office update, I always talk about discontinuation of services or report out on discontinuation of services. Our data has started over, of course, because the federal fiscal year starts on 10/1. So in the last month, we've had 0 discontinuation of services initiated. Next slide. Another thing I'd like to report out on is that our office has been cooperating over the last few years and assisting both USDOL Wage and Hour Division and USDOL's Office of Inspector General, which is their enforcement arm, regarding the investigation and data gathering of a farm labor contractor, actually farm labor contractors, who have which have not been in compliance with federal federal H2A rules and also state rules. We received communication from the OIG's office that in October 2025, I believe 48 criminal indictments were brought against principals of farm labor contractors with job orders that have had job orders in Washington state. And I believe that those indictments were issued in the federal court in Yakima. As I said, ESD, ASWS is directly supporting these investigations, and a OIG press release is forthcoming. It hasn't been released yet because the public information officer was on furlough, but we expect to see it soon, given that the federal government is now operational. We're going to decline to name the farm labor contractors here and let that be known when USDOL issues their release. Go ahead, Ignacio.
Yeah, so after this announcement is made, or has there been any discontinuation of services to these contractors?
Yes, there already has been. As to one, actually as to two, and but discontinuation of services was final as to one farm labor contractor. So, and they've also been subject to penalties and fines by USDOL wage and hour. But the scale of this investigation was pretty extensive. And speaking with the OIG agent, he stated that this outcome could not have happened without ASWS coordination.
Well, good job with that. And I guess my other question is, how do we keep them from popping up with different names or different owners?
Well, I think that's maybe a separate conversation, and we've spoken at length with OFLC about that, also with the National Minor Advocates Office, and also with USDOL wage and hour. There have been situations in which Washington employers have been debarred by USDOL. However, it is, I don't want to say common, but it is. It has happened that the principal individuals, reassociate and form a new business entity and kind of keep going using maybe names of associates, etc. So it is, there's not good controls, I think, on the federal level. On the state level, where we are tracking that to the best that we can by coordinating with L&I labor standards, specifically their FL or their farm labor contractor unit. I think that we're doing a very good job of that, but ultimately this is USDOL's program, and USDOL has the enforcement authority.
Bertha, I just want to say that I really appreciate that work that's been done, and this is a good step forward. I really appreciate your bringing this forward. I do think that this is not just a federal. Whenever you say that, I feel like we in the state of Washington have state laws that also do need to be complied with, and I think that there could be more done in terms of successor liability in stopping farm labor contractors who have had these serious violations from continuing to get licenses under different names. There is law of successor liability, and if we need more, we can strengthen that. But we do see the same names. In fact, one of the main people, and I'll say her name because I don't have any, Giovanna Sierra is still this year acting as a farm labor contractor, not under her name, but she is still acting as a farm labor contractor. And employers have to be on notice that if you're using someone like Giovanna Sierra, you are under FLICA going to have potential liability. But also there's more that could be done to refused licenses to those companies that are successors. Anyway, I don't think it's only a matter of federal law. We do regulate farm labor contractors in this state. So thanks.
I agree with Michelle, and I think we need, stronger, clearer regulations. And as part of this committee, I mean, I think this committee can play a big role in ensuring that, because that's the other side of the H-2A program and just in general, farm workers, right? How they find their jobs. But in rural areas, there's a lot of small um, players that create, their little farm labor contractors groups, and they move workers around, and it's really difficult to track them. But we get a lot of complaints of wage theft from these smaller farm labor contractors in Washington State. I think it is our responsibility to regulate them more.
Yeah, that
Go ahead, Bertha.
Oh, I was just going to say, yes, those points are very well taken. And, I think, 2 years ago, our office, I don't think had any coordination with LNI's farm labor contracting unit. They have field staff, they do investigations, they follow up. And so that partnership has been really valuable. I think that just and Michelle alluded to this, but or referred to this, but I think the a very positive outcome of these investigations and outcomes getting press is that it creates a buyer beware situation for employers who may not otherwise know, or may not otherwise understand that who they're going into business with are not credible, are committing criminal acts, etc. I know at least one of these individuals, my understanding, is in custody right now. So these are serious offenses, and it's a big deal.
I was also realizing that this might be an excellent topic for us to build into our report that we'll be writing next year, talking about strengthening that section of state ability to proactively manage this. So just wanted to mention that because I think we're going to be talking about that a little bit later in the meeting.
Right. And we don't want these type of operations in Washington State. I mean, really not nationally either, but to the point of what we can influence in Washington State. Um, they are not in compliance. They're undercutting employers who are doing things the right way, which is the vast majority of employers who use the H-2A program. So this is I personally also see this as a consumer protection issue. So we will share the press release when it becomes available. All right, next slide, please. Also wanted to announce, oh, excuse me. Oh, actually, Joy, would you like to take this one?
Yeah, I thought you wanted
Okay.
me to take this one. So
Yes,
I
yes,
do
go ahead.
want to alert everyone to some recent changes to our staffing. We're welcoming Margarita Cabrera back to the compliance team, and we're moving to a two supervisor model for the teams. Now, one of the things that does is we need to do some rebalancing and ensure that we have good coverage for all of the state, and that does challenge us with the position in the Northwest remaining unfilled at the moment. So I just wanted to assure you all we are not intending to leave that open. We are intending to ensure good coverage, and we're also looking to balance our staff's workloads and scrub the budget and do everything else we can do to make sure that we have adequate coverage within those spaces. Any questions? All right.
Thank you.
I guess I do just have a question.
Yeah.
Sorry, So is Susanna not there anymore?
No, Susanna
Or
is here. We're moving to a two supervisor model. So Susanna and Margarito are the two
okay,
supervisors.
okay, okay. Thank you.
And
I just when I
yeah,
need to call someone, I'm just like, wait a minute. Okay, thank
no,
you.
no, 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 no. That's completely fair. And that's one of the reasons why we wanted to say this. So, okay. All right. What's on the next slide, Vicky? Oh, yes.
So I also want to share a couple updates that we have been authorized or encouraged to share by both walk cares and paid family medical leave, which are both administered by the Employment Security Department. So temporary visa holders, this is walk cares, that is for that long-term care fund. It is well accepted that it's very unlikely that temporary foreign workers would ever see a benefit from that fund. Since it came live, they've had to submit annual exemption forms. That it's been really burdensome for the department because those forms are usually paper forms. It's been burdensome for employers because employers have really, taken the lead in helping workers to submit those. There was a legislative fix now that temporary visa holders are automatically exempt from walk cares. So no more paper forms, no more exemption requests. The department did want us to share that if there is between now and the first of the year, if you would normally submit an exemption for a worker, don't. They don't even have a way to process those anymore. It will all work itself out on 1/1/26. So that is a very good thing. The other thing too I want to point out too is that this is for foreign workers only. If you have a migrant farm worker from another state, they're not automatically exempt. So just that distinction is important. Okay, next slide. So paid family medical leave, so our compliance team, we've been hearing and receiving feedback from mostly employers who have data to indicate that there are potentially fraudulent or unsubstantiated PFML claims being filed by H-2A workers. And also in concerns that employers have been mostly kind of cut out from any type of feedback to the department about their concerns or about specific employees. We have data to indicate that these claims are being paid, or excuse me, filed by paid preparers, notarios, and that the evidence of the qualifying event may not be valid. So our team, we have spoken with PFML's fraud team, and we have coordinated some Zoom meetings as between employer HR staff and the PFML fraud team. The PFML fraud team would like us to pass on that the best way to report potential fraud is using their form, and there's a link to the form, and this is the most efficient. They need specific employee data, like a name or a claim number, etc. Just kind of generally speaking, hey, I think I've got some workers that they need to be able to have enough information to be able to kind of filter down to cases to look into them. But they are responsive. PFML fraud team has asked, they don't have any field-based staff, but they've asked our ASWS team to provide assistance and coordination, and we have the capacity to do that, and we are doing that. But not, perhaps not long term, just basically to enable the PFML frog unit to learn more about H-2A employment, meet these employers and establish a pipeline to report any frauds. So if you hear about preparers, fraud in your area, these H-2A workers may be unaware of it. It could be that that the purpose, the objective of this program is being misrepresented to them. We've heard that in some cases they're charged $700 to file a PFML claim. So we are including this, some information about PFML and what it is and what it's not in our site visit presentations. But please contact them via this form. I understand that the wait time on the phone is long, and so this form is the best way to communicate with that fraud unit. Go ahead, Ignacio.
Yeah, I think would be also a good idea for your team to visit the businesses where some of these workers are wiring money back to their homes, because some of these locations have notaries there. And I'm not saying that all notaries are doing this, but I mean, that should be the place where you also go out and do some outreach and talk to them about, this, if you're committing fraud, stop, because you will be caught.
Thank you. Next slide, please. All right, that's it for me. I'm going to hand it over to Olivia Gutierrez, who is substituting in for Petra Meraz, who had a appointment this morning, but should be back later on in the meeting when we unpack the 2025 AWR rule. So, Olivia, I hand it over to you.
Good morning, all. And I'm sorry about the camera. I worked really hard to get it to work, but it's not working. I'll get it next time. My apologies for that. So I'm Olivia Gutierrez. I'm one of the foreign labor coordinators, and I'm gonna be like Bertha said, I'm gonna be reporting today on behalf of the FLC team. Next slide, please. And this report is for our new program year, which started October 1st, 2025. During October 1st through October 31st, we did not receive any job orders due to the federal shutdown. Next slide, please. And this slide is showing the number of contracts and workers that are active for cases that started by and are ended after October 31st, which is 277 contracts with 28,368 workers requested. Next slide. And again, the number of applications and workers requested by AHO has been 0 due to the federal shutdown. And this is for the month of October 1st through the 31st of October 2025. Next slide. And this is the number of active contracts by AHOs. On the right-hand side, we can see the number of applications that were submitted. For instance, 84 contracts were submitted for Central Basin with a percentage of 40.77% workers, which is 11,567 workers. And then we have Columbia Basin, which a percentage of 12.5 with 3,556 workers. So again, this slide is representing the total number of active cases, 277, with 28,368 workers. And this is all my report for today. Any questions?
Olivia, this is John Devaney. When are you going to have the final compiled numbers for the previous program year?
Oh, that's probably a question for Bertha. Bertha, are you there?
I am. I'm sorry. The numbers for 2025?
Well, for the full program year, because we track by federal fiscal year. So now that
Right.
usually we track, how many total applications and referrals and total contracts and total workers requested for that program year, so that we can track year over year changes. When do you think you'll have those final numbers compiled?
We have the final numbers compiled, but we don't have it as a slide in this presentation. We do on the compliance side, but we didn't add it here. So what we can do is after this meeting, we could build one and send it out to the committee.
That would be really helpful. I'd appreciate it. Thank you.
Great. Tamara, Olivia, would you mind please committing to that?
Sure, we'll do that. Thanks.
Thank you.
Hello, can you hear me, everybody?
Good morning, Susanna. We hear you.
Good morning, everybody. Thank you for your attention. So I'm Susana Rodriguez, and I'm the one of the compliance unit supervisors. And then, yeah, hello, Michelle. Today I'm gonna present the program year 2025. That way you can see all the team, all the effort that we've been working on. So we can just move to the next slide. All right, so then this data, like I said, is reflecting the hard work for the team the whole year. So they were able to go to 454 site visits, and they reached 24,747 workers. And we saw an increase in the field checks in this year with the 16 of them, and that was based to 32 placements, 32 domestic workers. And you can see on the right top side, it's showing like how many placements were done per field check. And then the total complaints, the team they received 102 complaints they processed, and 9 of them they're currently in process, and then 58 of them they were informally resolved. So that was good because they were able to contact the employer, communicate, providing guidance, and having them to be up to compliance. And then 23 were referred to other agencies. So if we do a little breakdown, the complaints topics, we have other, as we've seen, is a large 63 of them. And in the next slide, I'll give you more information regarding the other. Wage related, there were 22, 6 complaints, they were regarding housing, 6 health and safety, 3 of them were sexual harassment, assault, 1 was regarding discrimination, retaliation, and 1 was human trafficking. And, oh, okay, go ahead, Rosalinda.
What other agency would the referrals to?
Yeah, that is a good question. So the agencies that we have been sending this to, it depends on the topic, and it will be the Department of Labor, will be LNI. So that will depend also on the worker, who they want to refer this complaint to. We have also sent some to Human Rights Commission when needed. Yeah, those are the main 3 ones that come to my mind.
Would it be possible to somehow list them in this report, just so that we can see where these complaints are going?
I think we could do that. You'll see in the next screen too, once we get to it, we have a pop out that we created to address the other category when we categorize complaints. We could probably do something similar for this slide.
Thank you.
Thanks for the question. John?
Yeah, thanks, Susanna. We heard early in the meeting about the Department of Labor OIG investigation. Is that complaint included in the total here, either in process or referred, or is that separate?
Can you repeat the question?
So early in the meeting, we heard about the U.S. Department of Labor investigation that was resulting in criminal prosecutions. Was that complaint reflected in your count here, or was that initiated separately through U.S. Department of Labor?
Everything is supposed to be included in here, and then in this case will be a referral also. I don't know, Bertha, that one, how long ago was that? Was that like, if this is the program year that it started the whole thing, then it should be included in this number,
I
right?
think so. So yes and no. So no, because the original referral of for one of the farm labor contractors was initiated in 2002 to wage and hour, and then in 2023 to OIG. For some of the other farm labor contractors that are in the mix, we do have some complaints related to those employers that are captured here. But that case is a conglomerate of issues, not just related to a specific complaint.
Thanks for clarifying that.
Thanks.
How difficult would it be to show these complaints by region? Like in the previous, there was a slide where it showed the number of applications per region.
I think we could do that. We have a new case management system that allows us a lot of flexibility in what reports we run. So I think anything is possible. Just to confirm, how would this committee use that information? Would it just be like for FYI, or tell me a little bit more about how the reason for that information being necessary?
Well, just to try to understand the activity in this, the site visits and the work that you're doing on complaints per region. I know that for us in our area, it would be good to know how many the complaint status and how many there were, because we, especially Familias Unidas, we're on the ground with workers, and it would just be good to see where we're at in relation to the rest of the state.
Yes, ma'am. That point is well taken. Go ahead, Ignacio.
Yeah, if I recall correctly, wasn't there some information that you gave out where the field checks are going to be different, or you're only going to be able to do field checks where workers are actually working? Is that correct? At the date? I can't remember what exactly, but it sounded like to me like
We
you
have
might have
less.
to do less field checks.
I can give an update on that, but do you want to maybe save that to the end of the compliance, just because that's a kind of not a separate issue, but kind of a separate topic.
Yeah, well, I guess my point is, if depending on what you announce, is if you're doing less field checks, and if I recall correctly, some of these complaints came when you did the field check. So you may have a reduction in complaints being filed. If that's the case, that where your field checks are not going to be as many.
That could be an outcome. So just I think quickly to recap, so that issue had to do with guidance from USDOL stating that the SWA would only have the authority to conduct the field check if the placement was still working for that employer on that job order as of the date of the field check. We have talked internally about that. We are seeking additional guidance from the department. It may be a policy decision by ESD rather than a rule or guidance from USDOL, but we haven't heard from USDOL, obviously, since we've made that inquiry. So stand by. As of now, though, we're business as usual.
Yes, okay. So we can go to the next one, that way we can unpack the other complaint section. So then here, based on your feedback, we were able to put in this slide what falls under other. As you can see, we have a large number if we go to worker termination and supervisor misconduct. And then the third largest will be worker recruitment. So we have been identifying this. One of our efforts is continue talking to employers regarding about best practices. Next month, the program is going to be presented in one of the conferences in Wenatchee regarding some of these topics. That way we can be better equipped. And yeah, and then just breaking down. Does anybody have any questions regarding this slide?
I don't. I think it's great information, but it also just makes me think I really would like to see all of this broken down by region. I mean, imagine if, there's 63 and the majority of the 63 are coming from a region where there's less workers going. It's just trying to see um, where we really need to focus for improving, for example, more training for supervisors or, the whole supervisor misconduct and termination. Is it just in one region? Is it spread out? That would be really helpful for on our side, I think, for workers.
Yeah, I hear you, Rosalinda, and thank you for the feedback. And that it will all these conversations allow us to go back as a team and really see how we can report better and provide better guidance to the team when it comes to complaints and what to capture, and how to report it. So thank you. And then this, I think I have one more slide.
Susanna, if I could just jump in, if you could go back to that slide. So on the left here, where you see the bar graph. So these 9 categories are prescribed by USDOL in the LEARS form. So LEARS is Labor Exchange, I don't know what the A stands for, report. It's escaping me what the A stands for, but these are the buckets that SWAs have to categorize their complaints in. And so when we forward our information or our data to the state monitor advocate on a quarterly basis, it's not useful for him to have it broken down kind of as granular as we have the other broken down. He has to get it as on the left, because that's what his form requires. So this committee reasonably requested an unpacking of the others so we could see the specific topics. And in our system, when we log our complaints, we have a drop down, we have definitions of each of these, and we have a drop down menu that allows us to categorize. So we can run a report either for the state monitor advocate in these bigger buckets, or we can run a report, like for example this committee, breaking down the other. And that's a new change, a new improvement that we've just been able to accomplish probably over the last few months.
Thank you, Bertha, for further explaining that.
Thank you, and I really appreciate all your work on this. It's great.
Okay, so then with this one, this is the data regarding HB 2226. So, and this is the time frame from July to September 30th of 2025. So as you can see, total workers requested is 17,694, and the total workers received, it is 16,158. And if you see down when it comes to number of workers requested, is this matching? 51% match the number. Then we move to the housing location, 94% it is matching the numbers reported to us, and work sites locations, 93%. It is what we gather when we receive, and just reminder, like this information, the team goes and capture this data directly from the employer. And I don't know if you have any questions or any suggestion regarding the data reporting.
I have a question. When you say worksite locations match, so the total workers received 16,158. This means that we know where those workers are then?
So the worksite location match, it is we are when we go and provide the data collection to the employers, they're listing where they're supposed to be working according to the contract provided to the FLC. And Bertha, you're more than happy that you can jump in to add more information, but that's what it means, that the worksite location.
Yes. So this is a point in time count, basically. Well, not count, but this is like a point in time report. And we just started collecting this data in 2024. And please note that this is just a quarterly report because the statute requires us to report quarterly. So this, yes, the it's self-reported data from the employer as of the date of the site visit or the field check, and they are reporting to us the housing locations where the workers are and the work site locations. And when we input that, we confirm that there's a match between the housing that was certified and the housing where they actually are. And as you can see, in 7% of cases during this reporting period, those didn't match. And sometimes it's, for example, there'll be hotels where they're in both facilities are owned by the same operator, but they're housing them in one of the facilities, but it wasn't that one that was certified. So in that, we actually just had a case like that. So in that, under those circumstances, we would advise the employer that they can only house in housing that is certified in the ETA 790. And in that case specifically, they moved the workers to the correct facility.
Could you explain the number of workers requested match? Almost 50% yes and no?
Yeah, and also I want to preface this by saying that during the last meeting, we talked about how we collect this data and also how we report this data. The statute requires us to report it to you, but not necessarily to analyze it. We want to have good customer service here and give you as much analysis as we can, but there's really not a prescription in the statute about how to do that. So this is when, for example, if the number of workers requested on an application is 50, but only 40 arrived, then that would not match. And this could be a situation where, workers didn't make it through consular processing, they've abandoned, etc., whatever the situation is on that particular day, that particular point in time when we're doing the site visit or the field check.
All right. Thank you, Bertha.
Yep. Yes, ma'am.
Thank you, Rosalinda, because I'm still learning the numbers, how to read them and how to report it. So your questions, I really appreciate them. All right, and I don't see anybody else, and I don't see anything in the chat. So I think that's my last slide, right?
Yes.
All right. Thank you.
You're welcome.
What do we have next, Vicky? What's up?
Well, you wanted to pop in the roll call because we had a quorum at this point.
Well, let's go ahead and do that. Let's go back to our roll call and we'll approve the minutes. And then we'll go ahead and take a break until 10:30. How's that sound? So, Vicky, if you could please call the roll.
Thanks, Joy. John Devaney.
Yes, I am present.
Mike Kempler. Elizabeth Strader.
Present.
Delia Pena,
Present.
Michelle Besso,
Present. Sorry, I just had to get to the mute button. I'm
Michelle,
present.
I know you're there. Rosalinda Guillen,
Present.
Ignacio Marquez,
Present.
Uriel Iniguez or Caitlin Gates.
I'm here. I think Kaylin's also here.
Okay, thanks, Uriel. And Juan Gamez.
I'm here. Thank you.
Jeff Peralt. Okay, looks like we have a quorum, Joy.
Excellent. So could you please bring forward the minutes that we need to approve? Is it one set or two?
It's just one set.
Okay, awesome.
Let me stop sharing and pull those up.
All right. Oh no, I caught her. I caught you off guard. I'm sorry, Miss Vicky.
You did, and it always takes my PDF reader a little bit to get moving.
It's
Like
okay.
not quite warmed up in the morning.
All right, so we have forgive me, I'm trying not to sneeze. We have the minutes from our previous meeting in September and wanted to bring those forward to the committee for review. Everyone should have received these by email as well. Are there any corrections needed to them or questions about the content? If not, I would entertain a motion to approve the minutes.
It's John Devaney. I
I
move approval of the September minutes.
actually I have a question,
Yeah,
Joy.
Michelle.
I wondered, I realize we don't want to have full minutes when we have the recording,
Mm-hmm.
but I did wonder if um, we should be trying to preserve in the minutes any decisions made. I mean, I think, for example, a topic that we've decided that we're going to be following up on. I mean, at the moment,
Right.
these only preserve who was there. And I get it. We can go back and watch the recording, but I just want to throw out there for the future. I will not interfere with this one, but I think we did identify topics for further discussion.
Oh, okay.
And
I see what you're saying. So maybe some next steps and just,
yes,
summary.
yeah, that's all
Okay.
I was just thinking. Thank you.
Yeah, we can take a look at that. So with that, can I impose on you for a second?
Yes, I second.
Excellent. All in favor, please come off mute and say aye.
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 Thank you.
Aye.
Excellent. If we have any opposed, please come off mute and say nay. All right. I'm going to take that as we are approved. Thank you very much. So let's go ahead and take a quick 20-minute break. We will start up again right at 10:30. Thank you all. If so, could you? Awesome. Thank you so much. So let's go ahead to the next section of, where are we at? We're at the 2026. Ah, this is where we're at. Do we have Bertha back? I should have checked.
Hi.
Hello.
Hi.
Hi. Okay, so let's go ahead and jump into the AWR rule.
Okay, perfect. And just want to confirm that Petra has joined us. I think she has, but I just want to confirm that.
Good morning. Yes, I am here.
Morning,
Hi.
Petra.
Okay. So the 2025 AWR rule, as we know, this was published on 10/2/2025. It is a final rule, but it is a 60-day interim final rule, and public comment is currently being accepted. As Joy stated earlier, ESD and LNI are working together on public comment, which would address some of the impacts and some of the potential issues that we see with the rule. But everyone is invited to make their own public comment, and we'll have information on how to at the end of this segment. So as I said, it came out 10/2. Then the government was mostly shut down. It was effective immediately. So since we've just opened up in the last week, there really hasn't been a good test run for this rule yet. But the intent today is just to highlight some of the more major changes and provide some examples just so everyone can get a good orientation on what this rule changes and what it doesn't. Next slide, please. Okay, so this is meant to be a discussion among the committee members about their reactions and their feedback regarding these rules. Again, ESD will not issue public comment on behalf of this committee. However, committee members vis-a-vis your own organizations can provide your own comment. One of the changes is that the AWR, which was calculated from BLS OEWS data, or excuse me, it will be calculated based on BLS OEWS data versus the Farm Labor Survey. I'm not an expert on the Farm Labor Survey, but my understanding is that this in practice may have not that big of an impact, but I opened the, well, actually maybe we'll go through these and then we can talk about them. The next, and probably the one that is I would say that is generating the most questions to our staff, is the creation of 2 wage tiers based on what the job requires. So the focus is on what the job requires, not on the experience level of the worker. Under the old rule, there was no experience tiers. Under the new rule, specifically for Washington, the tier 1 would be paid at $16.53 for farm workers and entry-level positions. Starting 2026, that will be below the Washington minimum wage. So this would not be the highest applicable wage as is required. And for skilled positions or tier 2 positions, the AWR rate would be $19 an hour. I'll go on to the next one, and then we have one more slide of rules after this, but the other change that is getting a lot of attention is the adverse compensation adjustment, and this pertains to only H-2A wages only. I've heard this referred to as a housing deduction. it's not a deduction. It won't be deducted from the H-2A workers' wages, but rather it's the setting of a new wage rate for H-2A workers only, taking into consideration that domestic workers, if they're not eligible for free housing under the rule, then they would be on their own to provide their own housing. So this Washington AWARs for both entry level and skilled H-2A workers are adjusted to account for employer provided housing. Both of these adjusted levels are below the 2025 state minimum wage. Please keep in mind that employers still have to pay the highest applicable wage. We want to pause here for some committee reaction or discussion about these three changes.
Bertha, this is Dahlia. I have a question. Just to make sure I'm understanding this correctly. So local workers, we'd be paying one rate and H-2A workers would be doing the housing deduction. It's like a what, $2.49 rate, right? That I'm understanding that we could apply for the housing deduction. Is that correct?
The adverse compensation adjustment, not a deduction, but that would be applicable to H-2A workers only. And my understanding as to what we know so far is that it wouldn't apply to non-H-2A workers who are being provided employer provided housing. Petra, is that your understanding as well?
Yes, that is correct. But also, just really quick, if I can add, no workers in Washington can make less than the minimum wage. So even though DOLs had stated that they were at 16.53 in the Washington state, the minimum wage is $16.66. So no worker can, even H-2A, no worker can make less than the minimum wage.
Then all workers have to make at least the state minimum wage.
That is correct.
And if a grower were to decide to maybe not do as much of a deduction or decrease in the wage for housing, would they have the opportunity to do that, or is it a required, you have to do this and don't go below the federal state minimum or state minimum?
I think it's required. There's no discretion on the employer. I mean, you could offer more in your wage rate, but I don't think that you could modify the compensation adjustment. And Mr. Devaney has his hand up.
Yeah, Bertha, my understanding was that it's not a deduction that an employer would take. That the Department of Labor was showing the calculation that went into setting the adverse effect wage rate. And so the employer just has to look at what is the federal adverse effect wage rate for those foreign workers and what is the state minimum wage and pay the highest of. There's not going to be a deduction from their paycheck for the costs of housing.
Okay.
I hopped on to remind everybody that this rule came out the day after the government shutdown. Normally, when Department of Labor drops a rule, they also follow it with substantial guidance about implementing that rule and some examples of what it means and the nuanced questions that we're getting to here. We haven't seen that yet. And so we're only going off the plain language of the rule. And many of these things may well be developing over the next couple months as we go. We're doing our very best to get you the information as quickly as we can. The other thing we wanted to note was the combined comment on this rule from Labor and Industries and Employment Security Department is going to focus on the administrative changes and the administrative burden, not so much on issues of fairness, issues of anything else qualitative. It's going to focus solely on challenges to implement places where this creates further administrative burden and places where this creates confusion and error potential for everyone in the system. So just wanted to say that that is going to be the focus of our comment. So.
Also to state that this rule is effective on 10-2, but effective only for those applications filed after 10-2. So if you have a active application or an active job order filed before 10-2, this does not apply to you. It only applies to new job orders filed after 10-2.
Rosalinda?
And no, there is no piece rate wage. There's no piece rate included in any of this. All the H2A workers will only earn hourly wages.
No, so piece rate still applies, particularly in Washington, because of the FUJ litigation and injunction. So for the applicable prevailing piece rates, which I believe are pears and Bethra, help me out, pears and apples, right?
Cherries? No,
Cherries.
no apples.
Thank you. Yes, pears and cherries. Though the employer must include those prevailing rates in their application, and they must offer and pay them.
All right, thank you.
Doesn't eliminate the applicable prevailing piece rates. And we will be looking for those in the ETA 790 to confirm that those are stated on the application, if applicable. Also received some questions about language and what makes a position tier 1, what makes a position tier 2. There is some guidance. Well, there is, I think, some language baked into the rule about the number of months experience. So if it's over 3 months experience, then you're in tier 2. This will be potentially difficult to monitor for ESD. I think that, if the experience level is misrepresented, for example, if it's represented as a tier 1, but really an employer is requiring or the job requires tier 2, then we won't know that on the front end when the application is filed, but we will need to find out on the back end when the application is certified, when work is underway, and our compliance team is monitoring compliance of the job order.
Bertha, and these qualifiers for the tiers are set by the feds, it can't be set by the state?
I believe that's correct. Petra, do you want to provide? Actually, I'm sure that's correct, but Petra, do you want to provide any wisdom on that one?
Yes, absolutely. Thank you. Yes, so that ultimately, just remember that DOL has like the last word. They are certifying the contract, but yes, the state, the FLC team will put any notes on anything we think or anything that we don't approve. Also, when we review the contracts, we will send a notice of deficiencies to employers if they don't change it or they don't want to change it, and then we will deny the contract, and then we will send it over to Department of Labor, and they will determine if that contract gets, certified or not, and if there's any changes. But the guidance that we have right now, we haven't had any guidance. So as of right now, if we don't agree with something, we denied or we NOD, and then we move it to DOL.
I'm curious about the standard occupational codes. Are they going to change then?
That will be covered in the next slide. So the SOC codes themselves will not change. However, the applicability of the applicable wage analysis is changing. So we can go there now, actually. If you could advance to the next slide. So SOC stands for Standard Occupational Code, and it's basically a library that lists the what duties are included in that job classification and the applicable wage. And the determination of which SOC code applies is up to the SWAT. In the last few years, thank you very much, Josh, Standard Occupational Classification Code. And in the last few years, there's been, I think, a lot of confusion in this area, specifically when it pertains to additional duties, including like having H2A workers drive workers perhaps from housing to the work site. There's been an argument that depending on how the employer represents that duty in or describes that duty in the job order, whether you are still within the farm worker codes, which are all paid at the AWR, or if you are in like a chauffeur or a shuttle driver category. The rule up until this rule and the policy for DOL is if you had that higher paying duty in there, for example, a shuttle driver, then that higher wage would apply to the entire job order. So for example, if the chauffeur, I don't know exactly what the chauffeur was, but it was higher, it was like 20, so let's say it's $22, then everyone in that job order would be subject to that higher wage, whether they were performing that work or not, because that was the duty certified in the job order. How employers were managing this, and the correct way to manage it was to file a separate job order and have only, for example, like if you needed 8 of those stage 2A workers to drive, then file that. It would be the chauffeur wage, and then file, the rest of your crew on a separate application. The reason that it was so confusing is because it really kind of turned on one or two words, kind of magic words, as to whether you were, still in kind of farm driving or whether you were in shuttle driving, and that higher code and that higher wage applied to you. So now that analysis is eliminated. Now this rule are most of the job duties described in the job order within what's called the Big Six SOC codes, which is like the farm work codes that are all paid at the AWR. If yes, then the AWR applies to all of that work. There's no kind of carving out that higher wage if that higher wage SOC is included. So this really shifts the analysis for the SWA from looking at how the job is described and whether it's in another SOC to an analysis of what duties are being performed the majority of the time. Is the driving just incidental? Is it is it like, they're only driving 10% of their time? If that answer is yes, then under this rule, as we understand it today, then the AWR would apply. And Petra, please feel free to fact check me if any of that was not right.
I think you're good. That's what we understand as of now.
So a function of potential impact of this is that maybe we'll see less job orders, because now instead of filing separate job orders, they can all be included, all workers could be included in one, with those additional duties not being performed the majority of the time. It's possible that, that's the immediate impact that I think about.
But that also means that all the workers will be paid the lower wage. If the majority are lower wage, then the high skilled workers will be paid the lower wage also. Okay.
Another thing that the new rule tells us is that that any AWAR adjustments or adjustments to the adverse compensation adjustment, which is only for H-2A workers because of the employer provided housing, that usually that these will fall mid-year. This year, that mid-year was like 4th of July weekend, which is, well, 1 week before 4th of July weekend, which was in some areas the very peak of cherry season, which is probably the very worst time that you could potentially make a change because that wage change is effective immediately, maybe in the middle of your payroll cycle. But this rule does tell us that expect that to be when changes are made. And then finally, as we said, the effective date is 10/2/25. It's for applications filed after 10/2/25, not for active applications that have been previously certified. As I said before, we've had a very limited test run because Flag has been inoperational. So now I think Petra, are we up to 13 applications filed since 11/3?
Yes.
So yeah, so they're trickling in, but we haven't really seen, I mean, we just don't have enough data yet to kind of analyze what the impact of these rule changes will be.
And also, if I can add really quick, another thing that when Bertha said that we might have less applications this year, also just remember that employers are also now able to staggered. So before they used to file like 3, 4, whatever number of applications because they had different dates. Now they can stagger them. So that's another reason why we will see less applications this year, I believe.
Right, and the staggering of workers is not a rule change, but rather a policy change by USDOL that was announced prior to this rule being published. It basically means that if you have, for example, 60 workers certified, that now if you have got some flexibility. Prior policy change, there was no staggering of workers allowed, meaning that your date of need was your date of need, and you were representing to the government that you needed all 60 on 10/1/25. Now, as an example, now there's some flexibility where it's permissible that you could, bring 20, on 10/1, you could bring 20 on 10/10, you could bring 20 on 10/20. This provides some flexibility for the employer, especially when it comes to, unpredictable factors like weather, etc. But that is a policy change. Our compliance unit did a lot of work over the last couple of years educating employers about that not being permissible and encouraging them to file separate job orders for separate dates of need. But now that it is permissible, employers have that flexibility.
Bertha, I have a question, and I haven't looked at this. I need to look at that policy. How is that going to affect local recruitment? In other words, how are you going to know if a worker applies and they say, well, actually, that job isn't available yet? In a month, come back? I mean, how is that going to work?
Good question. And I don't think I know the answer to that. I do know that employers have to state on their ETA 790 how they will stagger. So it's not, so pre-certification, the SWA will have an idea of how, of kind of how the split will happen. I'm assuming in practice, it would be that the worker would be referred, and then the employer, I don't know if the employer would have the obligation then to hire them no matter what stage they're in. I'm assuming the answer to that is yes, but we don't know. Vicki, if you could go to the next slide, please. So public comment for the interim final rule closes on December 1. ESD and LNI, we plan to meet this deadline. Logistically, Joy, where do you email? Where do you submit them? I actually don't know the answer to that.
That is such a good question, and I will drop the federal filing link into the chat, but we will also include that in the minutes, and um, we can send it out as well. I think it's no, not that one. I will have to pull it up. It appears to have closed when my computer closed last night. I'd love that, but I will get it for folks. Okay. And folks, thank you very much for your patience and grace with this. Like I've said, we are doing this with very little guidance, and you've asked a lot of questions that we just do not have solid answers for yet. We will continue to update with what we do know. It may well be an email we send out as we begin to figure this out. But we will get that information to you as soon as we know. Okay. All right. Vicki, what do we have on the next slide? Oh, Bertha, you have a proposed agenda for us, don't you? Or not agenda, but meeting schedule for us.
Yes, and Joy, please be a part of this conversation too. It's pretty open-ended. So, as you know, historically we don't have a advisory committee meeting in December, and our last regular meeting of the year is in January 2026. So we will adopt you as a body will adopt a 2026 meeting schedule. As Joy said, it is a legislative reporting year, and so we will be on a schedule for compiling that report. And so what this year, as you recall, we didn't meet monthly. We had 2 in-person meetings in Olympia. And then we kind of filled in the off months with virtual meetings, usually on Thursdays. This was a special case because we didn't want to conflict with another conference happening. So we would like to hear some feedback from the committee about frequency of meetings, composition of meetings, all of those things. We want to be responsive to to the desire of the committee and the work that you will need to do next year.
John.
Well, my suggestion is that we meet every other month. Okay. And then do at least 2 in-person meetings. It was a little bit difficult. I feel like this year having the timing of those meetings. I think they were from like 9 to 1, which in Olympia, which made it difficult for those of us coming from Eastern Washington to get there. And then I don't know. Anyway, I'll hear what John has to say, but I would like to look at whether we could do at least one in Eastern Washington again. That's the other thought I have.
Yeah, thanks. So couple of observations about the meeting schedules. If we're doing a report, we'll probably have to meet more frequently than quarterly next year. Monthly is a lot.
You cut off for me, John. What did you say? I'm sorry.
I was saying that I agree that if we're writing a report next year, that quarterly meetings are not going to be enough. And I believe monthly is probably too much. And so I agree with you, Michelle, that every other month probably is a good pace of meetings. Procedurally, I think that to be most effective in our meeting time, I think that having the agenda out to us farther in advance of the meeting would be extremely helpful. I know that there's a lot of staff work that goes into preparing those, but we often end up as committee members springing questions on you at the meeting, and we feel like we're harassing the staff to some extent to ask you pop quiz questions, but I don't feel I can always prepare those in advance if I get the meeting agenda the evening before. And so if we just committed to having the agenda, at least a draft agenda out at least a week before the meeting, and then we could put in requests for information or agenda changes, saying that requires more discussion. You could finalize that before the meeting. That would, to me, make me feel like I would better prepared for meetings, and when we're in present, that the time is more effectively used. I also agree that a couple of in-person meetings are great. And when we are meeting in person, whether it's west side or east side, I think that scheduling midday, as Michelle suggested, is a great idea. I'm a morning person, so I can get to Olympia by leaving at 4 or 5, but not everyone likes to do that the way I do. So I think doing midday would make a lot of sense for those in-person meetings.
I think that makes a lot of sense. I do. Also, John, in response to the comments about the agenda, we completely hear you. Please note, we do not we take those pop quiz questions in stride, because we know that we've jammed this week and this month in particular were very full, and our apologies for the late notice. ESD broadly is looking to standardize and have better advance notice for all its advisory committees. So you may see some small changes to the way that we communicate just to get us in line with like the UI advisory committee and the PFML advisory committee. We're working on making it so that your encounter with ESD is more predictable, regardless of which group that you're working with. But that does include certainly no less than 3 business days ahead of time. I think, having agenda topics out to you all a week ahead of time is certainly not a bad thing, especially because as we're going into a report writing year, there's a specific cadence we're going to need to be on. There's a project management schedule we'll need to be on. And there will be times when that the meeting is going to have a focus specifically on a question that we want to dive into and we want to develop for the report. So completely agree on that. It's a short session, which is a good thing. At the same time, the legislative session does tend to get in the way of some of our meetings. When we're talking every other month, are you envisioning basically like 6 meetings next year, or are you really thinking January, March, May, July, etc.?
Could you repeat that?
Okay, so when we talk about meeting every other month, the quick math in our heads might be, okay, so that's 6 meetings over the course of next year. With legislative session and with report due dates, that might end up being that we only get 4 or 5 meetings into the space where we're trying to write the report. So my question is the goal to have 6 meetings before we finalize the report so that we have that time to work together? Or is it truly approximately every 8 weeks we want to have a meeting? Because there's different ways we can schedule it.
The report is due to be done by,
I want to say December 1st because that's our usual.
okay.
I could be wrong, but I think that's our
Actually, no, it's published on 1031. So we'll
Oh.
have to have a final copy for accessibility review, all of that, 8/1.
August 1?
Yeah.
Ooh. Okay. So yeah, that's a good parameter to know. So if we need to be agreed to a report, that needs to factor into our thought process. John?
Yeah, based on that, I would say that perhaps doing January, March, and then
April, May,
a couple
June.
of monthly meetings in the middle of the year as we're finalizing drafts.
Okay.
And then once it's submitted in August, if we have one more meeting before the end of the year, that may make sense. I was thinking in terms of total number of meetings, and I see what you were saying, Joy, not necessarily committed to every, alternating months on a very fixed schedule.
Okay, that sounds good.
I mean,
So
June and July is really difficult.
we can adjust
Yeah.
around that. You know, if it's early in June and then late in July and to finalize, with perhaps like if we were to need the feedback, we could do that through emails potentially. We could also possibly have short 1 hour phone meetings that are solely focused on a particular section of the report, that kind of thing. And we might even get those on the schedule now and have them able to be set aside later or canceled later. Okay.
So if maybe you could draft some suggestions and email them
Absolutely.
to us.
I think we can do that. I will work with Bertha and Vicky, and we can put that also against a bit of a project timeline for the report, and ship you both and show you where we've got those.
Hi, Joy. This is Juana. If I can
Yeah,
just
hi, Juan.
add, thank you for passing this along and letting us kind of put a vote on it and potentially have ideas and next steps. And I like what Rosalinda just said too, maybe just providing us with, so I echo what she said, but I also wanted to say that for participation, at least for DOH, we're still under a travel ban. So even if you do everything on the west side or on the east side, we can't travel for the foreseeable future. So we will always potentially be joining virtually. We did plan to potentially next year. We have new inspectors, so we wanted to at least if make it into a one meeting in person next year, or maybe two, and bring some of our inspectors along too. The only problem is that if we all come, let's say three of us come, Jerry, myself, and an inspector, we have to pay for our own mileage, our own, usually the agency would pay for our mileage, and most of us are either on the west. So even if we don't come, we might send a lot of our inspectors are Central Eastern Washington. So we might send them to be in person so that you all can meet them and see their faces and stuff, and they can be in the audience and interact. Obviously, not participate in the meeting. Jerry and I would be they can participate and interact with all of you, but I'm just saying that unfortunately, because of the travel ban, if we were to come, we would have to pay for our own way, which we don't mind at least once a year, but it would just make it difficult. So please plan accordingly so everyone else can attend. But just wanted to put it out there that for us, that's the foreseeable future. Thank you.
Understand completely. Thank you, Juan. Ignacio.
Yeah, I mean, I'm also limited as travel, but I always make it work. So if there's anyone that needs to carpool with me, I'd be more than happy to help out with that.
That is fantastic. Yes. Especially for those of us who are Olympia based, we can work on some carpool options to reduce the hit on these things. I think we will also, if we are scheduling an in-person meeting midday, um, we will do our best to get a lunch scheduled in there as well, so that we've got that covered and we don't need to worry about that. I know that's been sort of back and forth this year. Okay, so we will certainly have a hybrid option for every meeting. We will work on at least two in person. We will get sufficient meetings, approximately 6, scheduled over the course of the year, weighted into the report writing time and being sensitive to the incredible busyness of June and July. Dumb question, but if we were to need you all on the phone for an hour in that June, July timeframe, is 3:30 in the afternoon a decent time because work is kind of done for the day, or is that a terrible time? Or would it need to be an evening thing?
Uh, I'm just gonna speak for myself.
Mhm.
That would be a good time for me. I'd rather not do evenings.
Okay.
That makes our days just really
So
long.
long. Yeah, I can
Not my
imagine.
best time either in the evening.
Not mine either.
Yeah.
I'll tell you. Of course, my best time is not in the morning either, so I don't know when my best time is. Anytime I have a cup of coffee in hand, maybe. Okay. That gives us, I think, enough information to draft out a schedule and put that against the report. So, Bertha, what else did we want to hit in this particular section? Not just the schedule, but
Well, in years past, we have sent out a survey about, content of meetings. We've been responsive to those comments and that valuable feedback. Last year we heard, hey, like, let's make it less lecture based. Let's make it more interactive. We want more time to talk amongst ourselves. So we've been intentional about building that in. We would love to hear how it's going. If you like this format, if you want to hear less of us, if you would like to hear more of us, we're open to the desire of committee members. We could also send out another survey if that's the best way to collect feedback.
John.
Yeah, I would say that the format has been good. I would just refer back to my earlier comments that the more advanced warning we have what the discussion topics will be, the more we come prepared with thoughtful questions. Um, I think sometimes it's awkward if you give us a presentation and open it up for discussion and get echoing silence for 2 or 3 minutes while we're processing. And you think, well, there's no questions, we'll move on. And then we start saying, well, go back 2 slides. I have a question about that now. And so I think that that preparation will help the conversation flow better. And then just one other item related to both pacing of meetings and discussion is this committee loves our data. And when we talked about going to less frequent meetings, my understanding had been we were still going to be sending out sort of the monthly reports that Petra presents. We haven't been seeing those, and I would like to. And I know it's work, but especially if you have mentioned having a new report case management system, I think being able to generate those reports and send them out just to the committee listserv would be really valuable.
Point taken. I think we
I
can
hear
work on that.
you. I hear you. And admittedly, I've been thinking about that too, and that we haven't really honored our commitment 100% to do that. No excuses. However, we did implement our new case management system, and so we did have a bit of a transition there, but we we also have changed the way we present data. We're presenting it more dashboard style now. I think among our staff, we like that better. We'd love to hear from you about whether you like it better or if you want to kind of go back to more raw numbers. We've got some flexibility now. We can present it however you want to see it.
I guess I'm a typical person who values the content more than the presentation. So I like to see the numbers, and I might even reformat it if I'm going to take it and use it in my own discussions with industry. So if you can get the numbers out in the easiest format for generating it, I think we'll appreciate that.
I agree with John.
Okay. We can work on that. Let me confirm though, I don't expect we're going to have good reports for you in December, but we will work on getting them to you as a prototype to discuss at the January meeting. How's that? I'm just thinking holidays and making sure that we get it right. Okay, cool. Just want to make sure. All right. Well, with that, so a couple of things that I did here was we wanted to talk about ensuring that we have state tools for protection against nefarious actors in the system. So that will definitely be something that we can build into the report. Bertha, do you
Joy,
have
I'm trying to find my notes from last time, and I'm actually being very slow to be able to find them. But
Okay.
there was something we'd identified last meeting. I don't know if it was discontinuation of services that we wanted to understand better,
Hmm.
or
It might have been it.
hopefully
That sounds
somebody.
really familiar.
But I will keep looking.
Okay, and I
So a
will.
survey might be a good idea, just so I can be
Okay,
thinking,
that's fair.
going back and.
That is fair. And also, I mean, to the members of the committee, I will put this out. You don't have to wait for a survey. If you have a suggestion or a thought or a question, send Bertha and I an email. Um, we can absolutely take that and dive into it and bring it back. Okay. All right. Well, if we're going to send a survey, I'm going to let you all continue to mull on that. And why don't we go ahead to our closing slides? What do we have? So we'll go ahead and take public comment. If you'd like to make a public comment, including any suggested future agenda items, please state your name and spell it so we can capture it correctly for the minutes, as well as the organization you represent. Your comments are being recorded. However, if you would like your comments to be included in the meeting minutes, please submit them in writing via email to Vicki Carlson at the email shown there. And please limit your comments to 2 minutes. Do we have any members of the public who would like to make a comment? I'm not even sure if we have a lot of public members with us today. Yeah, everyone on the attendee list is a known actor in this space. It's good to see all our friends. In that case, let me also extend that to committee members. Is there anything that you would have for the good of the order? Anything you want to share or um, anything else? Okay. Assuming no, we owe you a couple things. We owe you that survey.
Joyce, this
Yes.
Sergio.
What you got, Uriel?
Yeah, yesterday an executive, I don't know if it was executive, an announcement by the AG forming a new group for worker protection. I think in the future, maybe sometime in the spring, or it might be a good to have somebody from the AG present on that. What does that mean? And at this point, I mean,
Okay.
so
That would be very helpful. I did not see that announcement. If you could forward that on to Bertha and I, that would be great.
okay.
Thank you. I like that though. If we can put those connections together with that group, that could be a very strong and solid way of moving forward. All right. Okay. We owe a survey.
I have a question.
Yeah.
I'm just curious about why not have somebody from the Attorney General's office just regularly, I don't know, attend or report or
We
be
can
more present with us?
make that ask. And we have talked about that a little bit in terms of what voices were missing. And we had a short list that we were building for that, but definitely we'll reach out to the AGs as well. And
I mean,
especially that connection with the worker protection group might be the right connection for this group.
well, but also there's so many changes happening at the national level that are intersecting with a lot of our work in Washington State.
Yes.
And I think it would be helpful for the Attorney General to be hearing our perspective on some of those things and what might be needed or anyway, I just think it would be, for us, it would be helpful.
I like that. And I will take an action item to reach out to the Attorney General's office and make that suggestion that they have someone attend these meetings. So, all right. Okay, well, with that, I think we're going to go ahead and close the meeting. Next meeting currently scheduled for Thursday, January 15th in the morning, virtual. If there is a challenge because of a session related thing, please let us know immediately. We're also working internally to make sure that we're aware of what's going on with the session calendar. If we need to adjust, we will give you as much advance notice as we can. But for now, that is going to be our meeting day. All right. And with that, y'all have yourself an absolutely lovely holiday season.
You too.
Have everyone get some good rest and time with your loved ones, and we are adjourned.
Thank you,
Thank
Joy.
you. You all
Thank
deserve
you.
a good holiday.
Thank you.
Bye.
Thanks, folks.
See you all in the new year.